On WFLA Now, this is Hey JB. Here's JB Buno.
For the first time, the Gabby Petito story entering a court of law as Gabby Petito's parents file a civil lawsuit against the parents of Brian Laundrie in Florida court. We have legal analysis and a live feed from inside the courtroom for this pre-trial hearing on WFLA Now, launching across all platforms. Good afternoon to wherever you're watching from, folks. JB here with you live on WFLA Now. The Gabby Petito story has gone through several different chapters, from disappearance to murder investigation to manhunt, and now into a courtroom. Let's show you a live picture of the courtroom. This is a live feed, and we have just been informed. In fact, there they are. The parents of Gabby Petito, we see there an embrace from Jim Schmidt and Nicole Schmidt. That is a live picture just coming in. They just walked in the courtroom of Gabby Petito's mother, father, stepmother, and stepfather entering the courtroom here for the first time. That is Pat Riley, the attorney representing them, for a 1:30 hearing. So we're about 20 or so minutes away from things getting underway. And of course, we will be here for you live to listen in for this lawsuit that has been filed in Sarasota County Circuit Court between Gabby Petito's family filing it against Brian Laundrie's family. The Laundries not expected to be in attendance, as we see Nicole Schmidt, Gabby's mom, Joe Petito, Gabby's dad. The plaintiffs in this case take their seats well ahead of time. Here live from Venice, Florida. And we're going to bring in now our legal expert on stream, Peter Tragos, the lawyer you know, joining us from right here in the Tampa Bay area. You might know Peter, of course. We had him on WFLA Now for our Johnny Depp Amber Heard trial coverage. Peter, it's great to have you back. I watched your entire 30-minute analysis on this hearing in particular and on this lawsuit. We have so much to go over, but first, let me just say thanks for joining us and great to have you on.
Thanks, man. Happy to be here. Always excited to come on here in Tampa Bay. This is the spot to be, on Tampa Bay.
And for folks joining us outside the viewing area, Venice, Florida, kind of on the southern end of Tampa Bay. We're a little bit more north. Peter, are you joining us from Clearwater?
Yes.
Okay, so Peter, not too far away in Pinellas County. We're here in Hillsborough County. As we're looking here, as the camera photographer now zooming in on a shot of the courtroom attendees behind the plaintiffs and the plaintiff attorney, that being Pat Riley, also here in the Tampa Bay area. We're live on WFLA.com, the WFLA app. We are live on YouTube as well. We will be launching Facebook here soon so that we're live across all platforms. To our YouTube audience in particular, hello there to you. If you haven't seen us in a while, of course, we still continue to stream, but I know that the Gabby Petito and Brian Laundrie story for many around the world has brought you perhaps back to the WFLA YouTube page, and I'm just saying a welcome, a good hello to you wherever you are joining us from. Peter, you've done a lot of analysis on this lawsuit. Let's make this clear. There are two lawsuits. We have this lawsuit that has been filed for an intentional infliction of emotional distress. We also have the lawsuit, the wrongful death lawsuit, that has been filed against Brian Laundrie's estate. We'll talk more about that in a little bit, but I want to focus for now on the lawsuit at hand. This today is a pre-trial hearing on the Laundries, as expected. No surprise, a motion to dismiss filed by the Laundries to get rid of this lawsuit. Of course, Nicole Schmidt, Joe Petito, Gabby Petito's family wants to see this lawsuit move forward so that, as they would put it, that more facts about what we don't know surrounding the Gabby Petito story are able to come out in this arena in a court of law. What's kind of your early take on this, Peter, as far as this avenue, this sort of choice that the Petito family has made to file this lawsuit against the Laundries?
They don't have a lot of choices as to what they could potentially file under in the state of Florida. So when we initially saw the first complaint, we were trying to figure out if it was negligent infliction of emotional distress or intentional infliction based on the verbiage. The reckless and wanton conduct, the outrageous conduct led us to believe it was intentional, and that's what it is. So we're here now on this claim that is very difficult to progress through a case with only an intentional infliction of emotional distress claim. And the reason for that, and this is purely a public policy reason, not because anybody thinks Gabby Petito's parents didn't suffer, not because anybody thinks that what happened was okay and we shouldn't have a civil cause of action. Purely, in Tallahassee, the legislators have basically said that we don't want to flood the courts with all the family members who are injured or who die as a result of an intentional or negligent act of someone else. It would flood the courts. It would bankrupt people. It would bankrupt companies. It would bankrupt insurance companies. So even though they were damaged by what happened to Gabby, we just don't recognize a claim like that unless there are certain factors, which is where we get into what's going on with this motion to dismiss. Was there an impact? Were they actually there? No. Was anything directed directly at them? That's a big question, because the Laundrie parents' silence, is that abusive language or something directed at the Petito parents enough to get them over this impact rule hump? And you can see, if you look at these actual motions, they give tons of examples as to what rises to the level of outrageous conduct. And just about every example, it is directed directly at the plaintiff, not at a family member of the plaintiff or something like that. So it is very difficult for the family members to come in and have a claim like this. And the IIED claim is usually a tack-on claim. If anybody's familiar with criminal cases or have seen some criminal cases where you'll have the big criminal charge, and then you'll also have a resisting arrest without violence because the defendant did not want to get handcuffed or whatever it is. It's a tack-on claim that usually goes away. When we see a lot of these cases where the IIED claim gets dismissed, usually there are other causes of action: wrongful termination, hostile work environment, a negligence claim, a wrongful death claim, a battery claim. All of those can continue. Lots of times the IIED claim gets kicked. So it's interesting that this is the only claim they have in this lawsuit.
So I want to kind of break this down from a non-legal perspective for a moment, or at least translate what you just said a little bit into just something that our viewers can, in large part, wrap their head around, Peter. This is part of what I do whenever I have lawyers on, trying to make sense of what we're talking about here. And what I'd like to know is, I watch your legal analysis on YouTube. Go watch it, folks. Lawyer, on YouTube. Peter does great work.
Thank you.
The subject matter of this lawsuit, really, this cause of action, is really what's happening here. Is we have a lawsuit that has been filed not because the defendants in this case did something, but it's because of what they didn't do. They're being sued for inaction. And what that inaction is, as a reminder, we're talking about September, when Gabby Petito's family, they're looking here at Joe Petito and Nicole Schmidt here live on your screen, when Gabby Petito's parents were desperately trying to get a hold of the Laundries, trying to find out where Gabby is, trying to establish any communication with them whatsoever, there was inaction. The Laundries didn't communicate back. And that is really the basis of this lawsuit. So then, Peter, how difficult is it to file a lawsuit and to emerge victorious in a lawsuit for something that the defendants, not that they did do, but that they didn't do?
So that's actually something that can happen in negligence cases, right? The absence of doing something that's reasonable to keep something safe, you can absolutely file a lawsuit on that. What's difficult and what makes this case is so interesting, right? You would think the wrongful death portion of it, because Brian Laundrie allegedly admitted that he was responsible for Gabby's death in a notebook or something that law enforcement got their hands on, the wrongful death case is kind of open and shut, not a lot of legal intricacy there. This case, on the other hand, has a lot of interesting legal factors, because not only are they suing for inaction, but they are suing somebody that exercised their Fifth Amendment constitutional right to remain silent against self-incrimination, which is one of the constitutional rights that we hold higher or as high as anything in our country. We cannot be forced to incriminate ourselves with our mouths. They have to have other evidence. Law enforcement has to be able to prove the case against us without using our own words if we invoke that right, which they did. The Laundries over and over again did. That's what's in their motion to dismiss, that they were exercising their Fifth Amendment right and First Amendment right, which I think is a little bit of a more of a stretch, the right to free speech or not to speak. But again, you're coming up against what's reasonable, what's proper, what's moral, what's kind, what's nice, versus what are our constitutional rights and protections in our country. And that's where we're kind of having this headlock here. And in the legal system, we're going to have to decide, are you able to sue somebody civilly for exercising their constitutional right and not telling you something that could have helped you and incriminated them?
What's interesting, too, is that this has been ping-ponging back and forth with various documents. Peter noted this on his video, that there's been, of course, the motion to dismiss and then the counter argument to that filed in court as well. One of the interesting things that we noted and was noted in my reporting on WFLA.com, speaking of the Fifth Amendment right, that the Laundrie's attorney argued that silence is what people would do and should do in that situation, given what transpired in early September. That is something that really irked a whole lot of people on the internet, this argument and this notion that had the same thing happen to you or had the same thing happen to the average Joe or Jane, that they too would and should remain silent and not communicate with the Petitos. That was an interesting moment as far as some of the, for folks just joining us and perhaps just getting reintroduced to where we are. And if you missed some of the back and forth in the months before this, that was an interesting development that had occurred. Live with Peter Tragos, lawyer you know, right here in Clearwater, Florida. JB Buno here with you in Tampa at WFLA News Channel 8, live with you on WFLA Now. You see the hashtags here on the left and right side of your screen. We actually have some new advancements here with our hashtag-based system. We're going to start to introduce questions and comments if you use the hashtags on your screen in the comment section, whether it be on YouTube Live or Facebook Live. We'll try to bring in some Twitter questions and comments as well. But use hashtag HeyJB, hashtag LawyerYouKnow, either one or both, and we can file in and animate your comments on screen. And just to show you exactly what I'm talking about as we go back to some of the comments that are coming in on YouTube Live. We have got Deidre Simmons joining us saying, hashtag HeyJB, I think it will be dismantled legally speaking. They may have acted immorally, but legally they had no responsibility to speak. Peter, real quick, before I have a couple of the notes to make, what do you think of Deidre's first comment that we have here on screen?
I think if this was just an everyday case, that it would get dismissed. I think because of all the eyes on it, and by the way, I've handled cases in this courtroom, in this jurisdiction, and before this judge, and this judge is awesome. He's very
really?
smart.
So you very interesting. No. That's interesting to me because it's only been in written context for me. So give us just a little bit of your interactions with Judge Hunter W. Carroll.
He's very smart. He is very considerate. He will actually read all of these motions and responses and replies prior to the hearing, which some judges don't. He will know what's going on in the case. He will follow what's going on in the case. He will hold the lawyer's feet to the fire, which I personally love. He will stick to the rules of evidence. He wants what's fair. He wants what's just, but he's not going to be swayed by the public opinion. He has represented actual people before, which some judges haven't. So that's good. So he understands what it's like to have clients and to deal with clients, which can be very helpful in a case because sometimes for lawyers, it's like, let's just kick this 3 months. For the lawyers, it's like, sure, we'll put it on our calendar. I keep working, and 3 months from now, when it pops up, I'll do it again. But for a client, that makes a big difference. When you can see Gabby's mom is crying. She keeps wiping her tears. This is stressful. This is miserable for her. So to just say, let's kick it 3 months and do it then would be brutal for her and her father.
So again,
very different for the lawyers.
So for those of you just joining us, this is a pre-trial hearing to hear arguments on the motion to dismiss. It's a 60-minute hearing. That's what it's been scheduled for in Sarasota County Court. We do not expect a decision today. A decision is expected at some point this summer on whether or not the motion to dismiss will be granted or not granted. And that's and if it's not granted, and this does proceed to trial, that trial would occur starting in August of 2023 based on the most current court records. But Peter, this is interesting now to me. You're saying that the level of attention, international attention that this story has received, you think that is going to perhaps play a role with where we are with this civil lawsuit?
I don't think it's going to sway the judge, right? So I want to be very careful and just upfront with that. I don't think it's going to sway the judge at all.
Right.
What I do think, though, is it will make everybody take a closer look to make sure and see if this actually is, because it is kind of specific circumstances, right? It's not just somebody doing nothing. These parents, the Petito parents, Petito and Schmidt, reached out to the Laundries trying to get them to speak. It's not just like the Laundries stayed in their house and did nothing. So I do think they have at least some kind of an argument that their inaction was actually active. It wasn't just purely passive. They actively chose not to do anything. I personally think that their Fifth Amendment right should be above and beyond having to speak in a situation like this. And I do think it would be kind of a dangerous precedent that that if somebody remains silent because they don't want to incriminate themselves and then they can be sued for something like this, I think that would be kind of a dangerous precedent. So I would think what factual and specific findings came down would be interesting from the judge. It's not uncommon at all to reserve ruling. And what you said is interesting. He can either grant it or deny it. Right. But he can also grant the motion to dismiss without prejudice, which would allow them to file the complaint yet again, a second amended complaint. And then we'd be back here a few months from now because another motion to dismiss would be filed. So the key words would be grant the motion to dismiss with prejudice, meaning it's out. They cannot sue the Laundries for intentional infliction of emotional distress based off these facts.
This is live in the center of your screen between Peter and I. This is live from the courtrooms, the courtroom feed that we have. And we just got in some new video. I'd like to show this to our audience. This just came in. This is the family now walking in. Our terrific reporter down there in Venice today, Allison Henning, shot this video of them walking in hand in hand. You see there Nicole and Jim Schmidt. You see there Pat Riley holding the briefcase. And we've got, of course, journalists, reporters waiting for them. There might also just be some members of the public. Let's not forget that in Northport, Florida, outside of the Laundrie's home, there was a lot of folks paying attention to this story. And so there could be some members of the public. This is a court hearing that is, in fact, open to the public. So again, this was them a short time ago coming into the courthouse here in Venice, Florida. Let's get to the next question. We've got Spiker 4x4 joining us on YouTube Live, and we do have to reintroduce our audience, re-engage our audience on Facebook Live in just a second. But Spiker 4x4 saying #HeyJB, why are the Laundries not in court? Now, I've been in contact with Stephen Bertolino. Many reporters have been in contact with Stephen Bertolino, the longtime Laundrie attorney, and he indicated to me that the Laundries, of course, were not going to be there. Peter, I would imagine that's not a surprise to you, correct?
That's actually more common than the clients being at a motion to dismiss. And that goes for both sides. They can waive their appearance. They don't have to come to every pretrial motion. They don't have to come to every deposition. They don't have to be at every hearing that we have. That's Matt Luca there, who is representing the Laundrie family from Tampa. My dad and the managing partner of his firm over at Trombley and Haynes are very good friends and go way back. And Matt's a good guy. But yeah, it's actually more common for the clients not to show up for these hearings. But
you were saying Matthew Luca, is that who you were just talking about?
Yes.
And do you have any experience, while we're talking about it, any experience with Pat Riley, who's sitting back there in his chair next to Nichole Schmidt?
I do not know him. No, I've never. I think it's actually funny. Whenever I hear his name, Pat Riley, and my first glance at him, I kind of think of Pat Riley of the Miami Heat.
Yeah, Lakers coach, Miami Heat coach. Yeah.
Yes.
But no, different Pat Riley for those of you joining us, even though there is a little bit of resemblance there too. Certainly doesn't help. But Pat Riley, the attorney, again, and the reason why we have different attorneys, you might remember the name Rick Stafford, who was representing the Petito and Schmidt family up in New York. Again, you have to be licensed to practice law in Florida to, of course, represent and deal with the case in Florida. So we have new attorneys here, Pat Riley, Matt Luca, and I've been told that Stephen Bertolino, the attorney in East Islip, New York, who has represented the Laundries, will be appearing in this hearing and doing so virtually. Folks, we're going to take a 60-second break here in just a moment. I'm just waiting on our team here. We have to engage our Facebook Live audience. Anything to note real quick, Peter? We're waiting on just our cue here for Facebook Live to begin. Anything that you want to note about just about where we are right now with this hearing about to get underway?
So motions to dismiss are granted very few and far between, less than, I would say, 5 or 10% of the time. And if they are granted, 99% of the time, they are granted without prejudice. So that is the most likely outcome, is that either it's denied or it's granted without prejudice. I will say most of those cases and the statistics in those cases are negligence cases, which are 99% of the time not dismissed, and definitely not dismissed with prejudice. This case would be within that more likely 10% area as maybe getting dismissed. So this is not a foregone conclusion. We win almost every motion to dismiss hearing that is against our complaints, but this is a little bit different than that. So really, I'm not positive what's going to happen as far as the outcome goes. I have my guesses, but I'm not positive about what's going to happen here.
Peter, don't go anywhere. Folks, we have to just really quickly reset. If you're on YouTube Live or WFLA.com, you don't have to go anywhere. All you have to do is watch a 60-second countdown. We'll be back in a moment with our Facebook Live audience.
WFLA Now will begin momentarily. WFLA Now will begin momentarily. Live on WFLA Now, this is Hey JB. Here's JB Buno.
A live look inside the courtroom in Venice, Florida. As the first time the Gabby Petito case entering a court of law, you're looking live at Joe Petito, Gabby's father, Gabby's mother on the right, Nicole Schmidt, as they file a civil lawsuit against the Laundries in Sarasota County Court. Great to have you with us wherever you're watching from. Now engaging our Facebook Live audience, joining our YouTube Live audience here on WFLA Now. JB here with you, and we're about to bring back in Peter Tragos, the lawyer you know, joining us from Clearwater, Florida, who's been providing us with some legal analysis. For those of you just joining us, we were about 2 minutes away from the hearing getting underway with Judge Hunter W. Carroll on this civil lawsuit filed by the plaintiffs in this case, Nicole Schmidt, Gabby's mother, Joe Petito, Gabby's father, against Chris and Roberta Laundrie for intentional infliction of emotional distress. That is the allegation, the foundation of the lawsuit, and really what it comes down to is in early September, if you'll remember, Gabby Petito's parents desperately trying to get a hold of the Laundries to get any information on where Gabby was located. It was a grueling process for them, as they would put it. Extremely troubling. They would go to the media desperately seeking information, and the Laundries did not communicate with the Petito and Schmidt family. That's really at the center of this lawsuit. And to perhaps provide a little bit more analysis, we've got Peter joining us from right here in the Tampa Bay area, joining us from Clearwater. Peter, again, a hello there to you. As we get underway, what's the most important thing for our viewers to know as this hearing gets underway in just a couple of moments?
He has listened to any analysis or breakdown about the motion dismiss, about the complaint, about the response, about the reply. There's not a lot of new information that comes out in these hearings. Sometimes the judge doesn't even ask for oral arguments. In a case like this, he's probably going to let the lawyers do their thing. They're going to repeat a lot of things that were in the motions, and then the judge will likely reserve ruling. He doesn't have to. Within his discretion, he can make a call right now and say granted or denied, with or without prejudice. He can make that call right now. But most people expect that he's going to reserve ruling, and then we'll find out later in a written order what his decision is and why his decision came down that way. But I would be willing to guess that this judge has already reviewed all the materials. He's going to listen to the oral arguments, and then he'll make his decision later. And it looks like the judge has just entered the courtroom. That's our cue.
Let's listen in. And we'll be back here with you live, folks, after the hearing is concluded.
And good afternoon. I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without delay. My preparation for all hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are two housekeeping items to address. First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom. If you have not received that authorization in advance, you may not record these proceedings. Second, we have two cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nichole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 1128. Ask the attorneys to please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nichole Schmidt.
Thank you. Mr. Luca?
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much. Now we are to hear the motion to dismiss filed by the Laundries, which is at document identification number, or DIN 33. The plaintiffs have filed a response, which is at DIN 38, and the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
I have to say, Your Honor, it's unusual to be staring at an empty spot up there at the bench.
Well, it is what it is.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that? Well, thank you, Your Honor, for your time this afternoon. I appreciate it. Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that, so I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak, and the state and federal constitutions support that. In our society, under our laws, people are free not to speak. Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case, paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Miss Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Miss Petito while the plaintiffs were looking for Miss Petito. Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Miss Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
Isn't under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint, is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
Your Honor, on a motion to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or I'm sorry, of the defendants for purposes of making that statement, that that the plaintiffs have not alleged sufficient conduct that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't think it necessarily makes a difference. I mean, I understand what the court's saying, that that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his clients by making a statement.
Okay, but when you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor, yes.
You may continue.
Thank you. Your Honor, the plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous, regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge, and that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. Even if that, I'm sorry, go ahead.
Let me make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information. They don't have to share it.
Okay, well, let's go down that road for a moment, because this is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true. And you're trying to get me to say that the complaint itself demonstrates the existence of a right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak, it does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, and somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability. Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider that conduct because that's a voluntary act by the Laundries?
I understand, Your Honor, and I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor. Is what are we going to require of people in a situation like this? Are we going to require them to say everything that they know, or are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor. And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. You know, people who are faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious, it's not intolerable in a civilized society for their attorney to make a statement for them like that. Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that the Laundries were somehow in an unequal position to the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Torts, Section 46, subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm, like, you know, I'm gonna cause you to lose your job, I'm gonna cause you to be arrested, I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme, such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor, certainly. Certainly, if you say words.
Johnny Depp just got found civilly liable for defamation by what his attorney said, right?
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it's not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true. That the Laundries knew where the Gabby's body was, and they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement, that he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he may or may not have known. It's really all about what the parents knew. And they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly. And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged it could be construed as trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about withholding medical care in the hopes that somebody dies so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney sort of boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So I'll move forward, Your Honor. I know we filed a motion and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint, and so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. You know, if the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, you know, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor, North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon its assertion that, since it is not a governmental entity and has not assumed substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel. So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. You know, the plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties. Your Honor, with regard to the affirmative defense, nobody's cited any cases where the legally permissible element is labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. You know, rather, the legally permissible element is really intertwined with the outrageous element. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action, the court explained how it applied in that case. And it said, the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, or from Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense, it's really part of the outrageous calculus, the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation where the court can't consider the defendant's constitutional rights. And in fact, in the case Huzzar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that this is not within the four corners. I mean, we know outside of the four corners, but not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I mean, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like, I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So, for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation, if there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right, a right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps like, you know, certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, you know, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything. That's just not the way our society works. It's not the way, you know, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they're able, they can withhold all information until it's compelled of them. That's, you know, or they're provided immunity by the government or whatever the circumstance might be.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not...
Let's get back, though, to legal duty. I hear what you're saying, that these facts might sound bad, but, you know, we're not talking about social mores here. We're talking about legal duty.
We're talking...
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. Admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive, and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother, tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because two of the debtor's children had been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, a complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? "We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress," and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, "the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage." In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, "The extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we too, we know she was our son's fiance, and we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway, so all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. And we're not talking about state action in this case. The defendant says we're asking the court to force the defendants essentially to say something. That's not what we're doing. We're seeking damages for their conduct. More importantly, the First Amendment does...
Mr. Riley, though, I want to direct you back to paragraph 30 of your complaint, where you say that the defendants were keeping the whereabouts of Brian Laundrie secret, and it is believed were making arrangements for him to leave the country. So that's something that the plaintiffs themselves injected into the case. So that's the basis of my question is, now that you've put that fact into the four corners of the complaint, isn't that the basis for me to consider, without having to need a affirmative defense filed, if you will, the constitutional rights of the Laundries?
Judge, what's the crime committed there? What's the crime if they are making efforts to try to remove him from the country? He's not been charged with anything. He's not a fugitive. There's not, that itself does not suggest that they were committing a crime. There has to be an underlying basis. If the complaint said there was a warrant out for Brian Laundrie's arrest and the Laundries were moving money around to try to move him out of the country, I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get him out of the country. Is that unlawful as it's pled in this complaint? No. It's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable, or mandating speech that a speaker would not otherwise make. In other words, the court continued, the right to refrain from speaking limits the government's ability to sanction or override a private individual's preference for not making certain speech. Not all speech, certain speech. So let's look at Overbay.
Mr. Riley, you have 5 minutes left, sir.
Thank you, Your Honor. Are the Laundries suggesting that we're seeking to compel them to mouth support for a view they find objectionable? Do they find it objectionable to tell a grieving family where their daughter's body is located and that she's no longer alive? Do they believe that they would have a personal individual preference for not making a statement that they knew where the body was located? That's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where is the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there. I'm not I'm saying that that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the fifth DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a second DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a third DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor.
No, thank you, Your Honor. May I be excused?
Yes, sir.
I don't represent any parties in the second case, so.
That's
okay,
fine.
Your Honor.
While Mr. Luca is cleaning up, is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115SC?
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
Okay. Well, Deputy Velez, if you could sound the halls for Barry Spivey as curator. Okay, thank you. The court deputy advises no response to the sounding of the halls. Okay, well, what's your intentions then in this case, Mr. Riley?
Your Honor, I've never had a situation where quite like this. So I don't think I'm obligated to give the Laundries 20 days from the time they were appointed as administrators ad litem to defend the action. But to avoid any future issues, I'm going to give them 20 days, and then I'm going to file for a clerk's default.
Okay. And you requested a jury trial in your complaint, I believe?
I did.
Okay, so we'll then have to have a jury trial on the issue.
Yes, Your Honor, we would be prepared to proceed to trial on that matter quickly.
Okay, well, I mean, it's a little premature relative to no default, but are you looking towards November, December, or what was your trial?
Without my trial calendar here, Your Honor, I'm not certain, but probably more likely sometime in early 2023.
Okay. Well, I mean, hopefully for case managements in the future, you can bring your trial calendar.
I apologize.
Okay. Well, we'll wait and see whether you obtain a default or if someone appears. Obviously, if someone appears, I want you all to go ahead and do the case management order and get deadlines set. And so that we'll get the case rolling. If you end up having a default, then we can set a trial. I don't think we necessarily need another case management. You know, we've got a November 14th, December 12th, then we'll, in the new year.
Your Honor, I can look at my calendar now.
Yeah. Well, I mean, I can't set a trial right this second because there's no default.
True. Okay.
But the reality is, because you requested a jury trial, we're going to have to impanel a jury on it, assuming that you're going to proceed with the case. I mean, obviously, if you decide not to proceed with the case, then we don't need to have it. But we'll call a jury, and we'll go from there.
Very well.
It's just, you know, I'm trying to figure out, you know, with all the other trials going on here and which judges are going to be here when, you know, just need to start planning these things out.
I hope that doesn't mean what I think it means, but for next year.
Oh, I have no idea which judge is going to be here in 2023. That's the chief judge's prerogative.
Understood.
Yeah. So I will not reset a case management if Mr. Spivey or an administrator shows up. I'd ask that you go ahead and do a case management order and send it in, a report. If it is a default, send my judicial assistant word that the default has been entered, and a couple of dates on our trial calendar where you're looking for the trial to be had, and then we'll go from there.
Thank you.
Assuming that there is a default, how many days of trial are you anticipating?
1 to 2 at the most. The witness list will be short.
I suspect jury selection will take us a little bit of time.
Well, yeah, that's why I was saying 1 to 2, because I think I could try the case in a day.
Okay. Anything else in the second case, Mr. Riley,
No, Your Honor, thank you.
No? Okay. With that, we're going to be adjourned for the afternoon. Thank you all very much for being here, and have a good afternoon.
Thank you, Your Honor. You as well.
Breaking news on WFLA Now. Here's JB Buno.
Arguments on both sides on whether the lawsuit filed by Gabby Petito's parents, you see them there, Nicole Schmidt, Joe Petito, will proceed against the parents of Brian Laundrie, not in court today. Our recap, our legal analysis begins now on WFLA Now. Hey there, everybody. JB here with you live. Of course, been watching every moment as you have here across all of our platforms on WFLA Now, Facebook Live, YouTube Live. The court feed is now going to break up. And in fact, you just watched it break up. And let me explain why. The court, our equipment now is going to move from inside the courthouse to outside. We have invited attorneys for both sides to speak to our reporter, Allison Henning, outside of the courthouse in Venice, Florida. So we anticipate hearing from Pat Riley, the attorney who you just heard, making the arguments for this to proceed to jury trial next year. He has indicated to me via text message that he does plan on speaking outside the courthouse in the post-hearing interview process. It's more unclear whether or not Matthew Luca is going to be speaking to our cameras. He has, of course, been invited to do so. We'll, of course, find out. But that's the reason why this feed is frozen. They're moving the equipment from inside the courthouse to outside the courthouse. What you really need to know is that we're, of course, going to stay here with you live on WFLA Now to provide you with legal analysis. Peter Tragos, lawyer you know, is going to be hopping back on the Zoom call here in just a moment to provide his expertise. But let's just kind of go over what has transpired. There was a lot of legal minutia, if you will, that I think that some people were perhaps a bit confused by. A lot of this came down to comparative sort of analysis of other cases that were presented. You might have heard other cases brought forth on both sides because of establishing precedent for what is being argued here in this case. Oh, just like that. Our crew is very fast. So we're now live outside of the courthouse, anticipating comments here from Pat Riley, and perhaps we'll hear from Matthew Luca as well. So what we're going to do is we're going to pay attention to this feed. You can see that reporters for various stations here in the Tampa Bay area have set up a makeshift podium, and we expect to hear from the attorneys, or perhaps, well, I don't know if we're going to get Matthew Luca. We're probably going to get Pat Riley. And whether or not the Petito and Schmidt family will speak, that is really completely and totally up to them. But we'll stay here with this live on this podium shot and continue to talk with you as we wait for Peter Tragos to come back in for his legal analysis, his take on what happened. I think that a lot of what you heard in arguing for the motion to dismiss from Matthew Luca, I think a lot of that was legal semantics. There wasn't much for people to really grapple onto as far as the case as we look here live. Let's go live now to Pat Riley coming outside of the courthouse. There you see Nicole Schmidt, her husband, Jim Schmidt, that's Gabby Petito's stepfather. You also see Joe Petito holding hands there with Tara Petito, Gabby Petito's stepmom. So let's see. I believe Pat Riley is going to come on over. Let's listen in.
Good afternoon, everyone. On behalf of Joseph Petito and Nicole Schmidt, we just want to express our thank you to Judge Carroll for the time he gave us today on the motion. We appreciate the time it's going to take him to make his decision, and we have no doubt that he will make the correct decision. The family will not be taking any questions, but I'll do my best to answer a few questions if you'd like.
How do you think the court hearing went today?
I was very satisfied and pleased with the question the judge asked, in particular about the statement that Mr. Bertolino made on behalf of the Laundrie family, because that says a lot. The fact that they knew she was deceased, they knew where her body was located, and they had the audacity to express a hope that she would be reunited with her family.
How is the family holding up through all this?
As best I can tell, they're handling it as best they can. If you saw, there were some tears earlier today when we came in here, and I expect there will likely be some more tears.
I know that the family isn't taking anything, but I noticed Nicole was holding on to her necklace. Are you able to share if there's a meaning behind it?
It's her ashes.
It's Gabby's ashes. I'm sorry?
And the card.
Oh, it's a mass card. It's a drawing or a piece of art that someone from Australia, I believe, created utilizing a picture of Gabby. And on the back of it is a prayer that Jim wrote.
The defense alleged that they had a Fifth Amendment right, even though there was no criminal allegations. How do you feel about that? I heard you arguing about that in the motion to dismiss.
Well, there has to be an investigation or a crime before the Fifth Amendment right applies. I don't know, and I'm waiting for the day for the Laundries to tell us what crimes they committed. Hopefully they'll do that someday, but I don't know what crimes they are asserting were committed. We did allege that they were trying to move some money around and get Brian out of the country, but there was no arrest warrant out for Brian. He wasn't a fugitive. From a criminal law perspective, I don't think that there was anything inappropriate about what they were doing at that point.
Was it upsetting not to see the Laundrie family present today?
I think for the Petito family it was a relief, but I would like to have had them be in the courtroom and face the people that they caused harm to.
How confident are you this will go in your favor?
Well, as I said, I like the questions the judge was asking opposing counsel about the statement that Mr. Bertolino made. If someone doesn't find his statements, knowing all the facts that were known to the Laundries at that time, if somebody doesn't find that offensive and outrageous, I don't know what's outrageous.
Did you read anything into the judge saying he'll need 2 weeks to give a decision?
No, judges typically take cases under advisement when there's a lot of research and a lot of cases cited, and so I'm not surprised by that at all. I'm surprised it's only 2 weeks. All right, thank you, everyone.
Attorney Pat Riley speaking outside the courthouse in Venice, Florida, as we watch Gabby Petito's parents and step-parents walking away, hopeful that the decision that is returned in 2 weeks' time is one that will proceed to trial and is against the Laundrie's attempts to dismiss the lawsuit that they filed earlier this year. JB here, back with you live, everybody, on WFLA Now. If I was just making sure that I was hearing that correctly, Pat Riley saying that that was Gabby's ashes that were there today at the, just kill some of that audio, at the courthouse, inside the courtroom. You also saw the prayer card there as well. I know that there are so many people, and I'm looking here now at the YouTube live comment section. Claudia, Marie, Josie, Lori, Sean B., a lot of folks joining us. People who have been saying justice for Gabby, justice for Gabby. So I saw the comment section light up when Pat Riley said that in this pre-trial press conference. And whether or not this is going to proceed to trial is going to come down to some real fundamental questions that Judge Hunter W. Carroll will have to determine where it sort of factors in as far as now the legal process going forward. But a lot of this came down to what you consider to be outrageous conduct. Now, the Petito and Schmidt family, what they are doing is claiming that when Brian returned home, the date being August 28th, when Brian was returning home from the cross-country road trip, that he informed his parents that he had killed Gabby Petito, and that the events that would occur after that, and really the lack thereof of events, would be proof of intentional infliction of the emotional distress against the Petito and Schmidt family. Now, a lot of what we have been talking about in advance of this hearing is the perceived inactions by the Laundries, choosing to exercise their Fifth Amendment right, something that you've been hearing a lot of in this pretrial hearing, choosing to exercise their Fifth Amendment right to remain silent and basically saying that they have no obligation to speak given that sort of situation. In fact, they argued in the motion to dismiss, it's something that, that staying silent is something that most people would do and should do. I mean, that's exactly how it was written. But also, what was also made a big deal of here in this pretrial hearing, which was a little bit surprising, I don't think that we really anticipated there being this much focus on this one section of the lawsuit itself, is this section where Stephen Bertolino, the attorney for the Laundries, released a statement. And I can't wait to ask Peter Tragos about this when he hops on in a moment. But I'll read the statement as follows, because this was the statement that came out from Stephen Bertolino representing Chris and Roberta Laundrie on September 14th, 2021. And it reads as follows. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. A lot was made about that particular statement that was released, and again, they referenced this in the pretrial hearing. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful. Pat Riley arguing that hope, giving that sense of false hope, rises to the level of outrageous conduct, rises to the level of outrageous conduct necessary for proving intentional infliction of emotional distress. Now, we had Peter Tragos on earlier, and he was saying that it is unlikely, I don't want to put words in his mouth, but he said it was relatively unlikely that at this stage in the process that this lawsuit would get dismissed, especially when you consider just how many eyeballs are on Sarasota County Circuit Court. And I'm not just talking from elsewhere in Florida. I'm not just talking about from elsewhere in the United States. I'm talking about from people around the world who are hyper-focused now on Judge Carroll, on this civil lawsuit, and whether or not so much is hinging on the Justice for Gabby movement. So much of that is hinging on where this civil lawsuit goes. Let me explain to folks for a moment why this matters for people, okay? Why this matters. There have been people that have messaged me and said, look, it's over. People are moving on. There's other news. There's other things that matter. And why does this lawsuit matter? This lawsuit matters because if this does, in fact, proceed to jury trial, there is an increased, and you could argue how increased, but there is a very much increased likelihood that there is going to be new information, previously unknown information, that is presented during the trial process. And there are so many people around the world who are still waiting for answers with the Gabby Petito story, the Brian Laundrie story. What really happened to this day? I noted this on my Instagram page last night. We still don't know why Gabby's dead. We still don't know why Brian manually strangled her to death. That is a question that to this point, to this day, still eludes us. We do not know the contents of the notebook that was found in the Carlton Reserve near Brian Laundrie's remains. We know that it contained a confession, if you will, that Brian had murdered Gabby, but was it Was there remorse? Was there a story as to what exactly happened between the two? Was it one sentence? Was it 4 pages? We just don't know. So there is this hope that exists out there that if this does proceed to jury trial, that stones that have to this point been, laying dormant are going to be unturned. And the facts of this case that are previously unknown will be finally known to the public. So many of you who have invested so much time in trying to find out what happened to Gabby Petito, why Brian Laundrie did what he did, and also, too, whether or not justice will be served. Will our civil court system do what really never got a chance? There was never a chance for Brian Laundrie to be prosecuted in criminal court, a criminal court of law. Reason being, he was found deceased of a self-inflicted gunshot wound in the Carlton Reserve. So criminal court cannot take us to the next level of fact-finding. But civil court might. That's up for Judge Hunter W. Carroll to determine. And a bit surprising, folks, a bit surprising. You heard there from Pat Riley, who I've had multiple conversations with over these last several months. We were anticipating this decision coming down in maybe late July, August, somewhere in that time frame. Judge Carroll saying that it's going to be delivered in the next 2 weeks. Very interesting. When we hear about that, by the way, whether this is going to proceed to trial, whether or not it's going to be a granted motion to dismiss or a rejected motion to dismiss by the Laundries, I assure you I will have it across all of my social media platforms at WFLHAB on Facebook, on YouTube, on Instagram. I have a public service announcement regarding other social media platforms in a minute, probably not in a minute, towards the end of the stream. I need to talk to everybody about TikTok for a moment, but that's a whole another thing. Let's focus on the facts of what has just transpired. Matthew Luca was arguing that this does not rise to the level of outrageous conduct, atrocious, outrageous conduct that would make it necessary for this to proceed to a jury trial. The exact opposite, of course, was argued by Pat Riley. And I think that there's more notes that I have here from Pat Riley and what he had to say. So we're going to start with Pat Riley, because I think that really the motion to dismiss on behalf of Matthew Luca, a lot of it came down to what was already previously reported in the document itself. It was pretty much a run-through. What Matthew Luca had to say was very much a run-through of what was in the court document that, of course, that we have been reporting on for the last couple of months. So let's kind of focus on what Pat Riley had to say. Some interesting moments. And I do Real Gamer on YouTube says this case has to be tried. I see hashtag HJB comments from SoCal, Renee Gal on YouTube, Brittany on YouTube, and we have a new system here. So hashtag HJB comments now are even more brighter and bolder, and it's easier for me to follow as your comments scroll on screen. So I'll really be looking for those hashtag HJB comments, and I'm really appreciative for everybody using that hashtag because it just makes it easier for me to focus in on your comments. But there was a couple of moments during what Pat Riley was talking about that really, I think, caught my attention and caught the attention of our audience here as well. I see Peter Tragos has just entered the Zoom room. We're going to bring him in here in just a moment. Actually, you know what? Let's bring in Peter now, if we can. Peter, welcome back. Good to have you back.
What's up, man?
Yeah, and folks, his legal analysis, you can find him on Lawyer You Know on YouTube. I'm sure that he's going to be talking about this case far more in depth as these days and weeks proceed and carry out. Peter, I want to go through my notes, and I'm going to go through my notes here eventually. Let me just throw this right at you to begin with. Who won the day? If you're just grading it on surface level from you being a legal expert here in our area, who won the day? The Petito attorney, Pat Riley, or the Laundrie attorney, Matthew Luca?
So I don't know if either of the attorneys necessarily won the day. I thought the judge won the day, right? To me, I thought he asked really great questions. He asked tough questions to each lawyer. He didn't give any softballs. He was asking certain questions to Brian Laundrie's lawyers that seemed good for Gabby Petito, and Gabby Petito's lawyer very smartly, Pat Riley, picked up on that. So he started talking about those points, because you can always tell what a judge finds interesting based on their questions. You give all of these documents, you produce all these cases and all these arguments. You don't know which one the judge is going to pick up on the most, but you find out when they're asking questions, just like an appellate case, any oral argument in a hearing, and a motion like this. And Pat Riley steps up and starts talking about those questions, about Bertolino's comments, about how he's an agent. He even references the Johnny Depp case, which I thought was so interesting, and how the lawyer's comments are as an agent of the client. Therefore, can't that be attributed to the Laundrie parents? And if so, isn't that outrageous because of what they said? And they didn't actually just remain silent and do nothing. But when it got to Gabby Petito's parents' lawyer, Pat Riley, he started asking difficult questions there, like, what is the legal duty? So I think the judge won the day with great questions. We still don't know which way he's going to come down. Based on his comments, I think that it's not going to be granted with prejudice, meaning I don't think he's going to throw the case out. I think it's either going to be he denies the motion to dismiss, or he grants it with leave to amend and potentially add more facts about that Bertolino comment, which you better believe I think they would do if they're able to amend this complaint again. But overall, I would say it was a slightly better day for Gabby Petito if I had to pick a party, because Judge Carroll did not seem like he's going to throw this case out. So I think that is a win for Gabby Petito at this point. But both lawyers did a good job. Both lawyers, especially the rebuttal for Matt Luca, talking about the flood of cases coming in. That is why the court and the legislature do not want these cases to be prevalent, and everybody's going to file a case like this now on all injury cases, and nobody in the court system wants that. And he made that argument at the very end.
Which is now, why exactly?
Because now for every individual case where our courts are already clogged, we will be able to file cases also for their parents and family members for extreme emotional distress caused by the person that hurt a child or a mother or somebody. There's a loss of consortium element, meaning loss of relationship, and a derivative claim, but you don't get your own claim as a family member, which is what they're doing here, based on, like, let's say there was a drunk driver and somebody left their house and come and kills my son. I don't have a claim against the drunk driver's parents for not stopping their son, but now I might. If they knew the son was drinking, if they saw this was happening, maybe now my son would have a claim against everybody because he was the one damaged. So anybody that had any negligence in the process, the parents, the driver, everybody, you can sue everybody if you're the son, but the parents don't have a separate IIED claim. And now they may with things like these claims if they're able to go through.
In the words of Matthew Luca, an avalanche of litigation. Exactly. Interesting choice of words there. Words that were also in the argument for the motion to dismiss in the written text that we were provided with, the court document. So interesting. All right, let's go through these notes here. I think that the Johnny Depp reference by Judge Carroll, just really quickly on that note, I think that speaks to Judge Carroll's acute awareness that he knows how many people are watching this hearing. And while it's not the hundreds of thousands of people that were millions, really, let's call it millions, that were watching the Johnny Depp Amber Heard trial, I think that Judge Carroll is very well aware that should this proceed to trial and should evidence be presented on that grand of a stage, that it's going to attract more attention than your average run-of-the-mill Sarasota County Circuit Court lawsuit. It's going to attract a lot more attention than your basic everyday lawsuit in Sarasota County, Florida. Let's get to some of these notes here. Pat Riley arguing. I thought that this was very interesting. Pat Riley said, I'm going to run through this bullet point list of notes that I have here on my computer screen, said that the Laundries, it's not as much about their choice to remain silent. It was as much about their actions after August 28th when they allegedly learned of Gabby Petito's death at the hands of their son, Brian Laundrie. And he said, Pat Riley said, the Laundries could have made an anonymous phone call and said, this is where Gabby Petito's body is. That anonymous phone call could have been made, and that the Laundries didn't choose to do anything other than really release this statement, the statement that I read earlier from Bertolino, where it says, on behalf of the Laundrie family, is that our hope that the search for Miss Petito is successful. What do you make of that point that Pat Riley, perhaps is it smoke and mirrors to say, wow, the Laundries could have made an anonymous phone call. They could have sent, a letter, an unmarked letter, and could have mailed it to the Petito or Schmidt family, and they chose not to. What do you make of that legal tactic, Peter?
I think it is a good factual argument. It is a logical argument, and it is an argument that will hit the emotions of the public watching. I think people will agree with that, generally speaking. But I think that it does not overcome the issue of legal duty. So do we have a legal duty to write anonymous letters into law enforcement or to the victims' families if we or someone we know commits a crime? And the answer is no. That's anti-constitutional, in my opinion, as far as the Fifth Amendment constitutional right to remain silent. So while I think it's a good emotional argument and, the court of public opinion, it may be a strong argument there, I don't think it's got a lot of legal backing as far as duty goes. And even Pat Riley said he's struggling to find and explain what the legal duty is in this case. How
about Pat Riley then going on to say that they didn't just remain silent, they went on vacation. And this is, of course, alluding to the now infamous, if you will, Fort DeSoto camping trip, that trip that was attended by the Laundrie family, including Cassie Laundrie, the sister of Brian Laundrie, who we've got an interesting number of questions about in our comment section as well. But Pat Riley saying that they went on vacation and went on and continued their normal life while the Petito family was deeply, deeply suffering. And that this statement, let's go back to this statement, Peter, that Pat Riley is arguing gave a sense of false hope. And that statement, in part, escalates this to the level of outrageous conduct that is necessary for intentional infliction of emotional distress. What do you make of that argument?
So a lot of people are asking as well, is it true? Do we know that the that the Laundrie parents knew all of this? The lawyer for the Petitos, Pat Riley, is like that. Am I freezing? It looks like I'm freezing on my.
You did freeze there for a second.
I don't know what happened there.
It's okay.
So he's saying all these things as fact because where we are in the pretrial phase, the judge has to take all these facts as if they are true, but they have not been proven yet. So proving what Bartolino knew, what the parents knew at that time is going to be very important. But let's assume they did know all of this at the time. Is that statement rising to the level of outrageous? Or is it almost a good luck or condolences? And how are we going to pick apart what people say in the media or through their lawyers as far as what their duty is in a case of IIED when something is going on? Is that going to make people come out and speak less potentially in a case like this? It's very interesting and I had people telling me that they said they hope they get reunited was part of the quote, but I remember the quote as you read it, which to me could still be factually true.
Peter, I have it right here. I'm gonna read it. I'm gonna read it again just for our audience here. And it was a statement released by Stephen Bertolino, the Laundrie attorney, on September 14th. And it reads as follows. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Right. So if you know she's dead at that point, that would be a lie and that would be giving them false hope. That's going to be Pat Riley's argument, assuming he can prove all that. So I would think they need to amend the complaint to flesh that out a little bit more. But with those facts, it seems like Judge Carroll may think it's good enough to get over a motion to dismiss.
What do you make, Peter? I was fascinated by your pre-hearing analysis of Judge Carroll and our comment section. I'm gonna be honest. Part of my job here in WFLA Now is to be a reflection of our commenters. Hello there to Barbara and Book Bakery and Marie Kitchen. A lot of the folks joining us in the YouTube live comment section. Our comment section lit up in support of Judge Carroll when it was very evident that over the course of these arguments being made by both sides, that he wasn't just there to sit back in his armchair and just listen to these arguments. He was asking a lot of questions, being very proactive, which is a reflection of what you were saying, Peter, before the hearing actually started, before everything got underway here on WFLA Now. So what did you take of Judge Carroll's, all these questions that he was asking for clarification on both the argument to dismiss and the one against it?
So I took that he reviewed all the documentation. he reviewed all the motions. He reviewed all the case law. He was asking the questions that were still kind of gray areas, right? Is the lawyer's statement count as their statement? Are they really remaining silent? What is the legal duty to Petito's side? Is the Fifth Amendment discussion something we should be having now? Was there criminal implications? You don't actually need an arrest or an investigation for there to be a criminal implication. He was asking questions that he knew the answer to make a point and hear how the lawyers would discuss it and answer it and make their arguments from it, which is exactly what a good judge should do.
Very interesting. We're going to start now to open up our live Q&A. And how this works is if you use the hashtags in our comment section, hashtag HeyJB or hashtag lawyer, you can use either one, and we can feature your comment on screen, and we'll try to talk with you. It can be an observation, it can be a review, it can be just thoughts, it can be just a hashtag, it can be whatever you'd like. Of course, provided that it's clean for our stream. So I'm going to start to really pay attention now to some of the comments that are coming in, and let's start here with Tyla. Tyla saying hashtag HeyJB, hashtag lawyer, why did the Petito/Schmidt family lawyer say he hoped that didn't mean what he thought it did about next year and not knowing the judge, etc. This also brings up the fact that the second case that was heard here in this hour, or this hour plus, was the second one was the wrongful death suit against Brian Laundrie's estate. Very important that we don't get these mixed up. We have the lawsuit filed against the Laundries for intentional infliction of emotional distress. Then we have the wrongful death suit that has been filed against Laundrie's estate. So to answer Tyler's question, Peter, what was that exchange there at the end, the very, very end, between Pat Riley and between Judge Carroll about this entering 2023?
So are you talking, I stopped watching it after they said nobody was going to show up for the Laundrie estate. So is this talking about the second case or the first case?
No, it's talking about the second case. And there was an interesting...
I probably missed it.
Okay, that's fine. Folks, this is a good opportunity for me to say you can follow Peter Tragos, lawyer you know on YouTube. I'm sure that's a question that he will get asked on live streams over there as he
Based on the context, he probably is just saying he hopes it's not going to get delayed as much as it feels like it's going to get delayed, because he has given the other side more time to answer the complaint because he wants somebody to come forward. He wants them to hire a lawyer. And at this point, everybody's just saying, I'm not responding on behalf of the state. Good luck. Do what you got to do. So maybe he's saying because of these delays, he's hoping that it doesn't last another year or have some kind of delay.
How about this one? Let's go to now this one from Titanician. Hashtag HeyJB. How come the Laundries weren't there? A, because they didn't need to be. And B, Peter, you're not surprised in the slightest, right, that the Laundries did not attend this? Can you, these two families. Would you go if you were them? Say it again?
Would you go if you were them?
Right, exactly.
I don't think I would. What good does it do for you to go and just have people scream at you in the public and everybody hate on you, and you don't have to be there? The judge doesn't order you to be there. I think it's understandable why they wouldn't want to come. They lost a child in this process too, and people think horrible things about them, and that's their prerogative. But legally, they didn't have to show up, and I don't think it should be held against them personally.
There was already tension in the room. If there had been... These two families haven't spoken. By all accounts, everything that we've heard, all of my reporting, all the conversations that I've had, these two families, to this day, folks, they haven't spoken. So the Laundries being there today, had they been there today, the tension in the room, you could have sliced it with a butter knife. It would have transformed the entire ordeal to have the two families on opposite sides of the room. So they weren't obligated to be there, and they weren't really expected to be. And I reported on WFLA.com in my conversations with Steve Bertolino that they were not expected to attend. Let's get to, this is the question that so many people were talking about, sending me on Instagram last night, and so many questions have been coming in about this. There's the notebook. The notebook that Brian Laundrie left behind at the Carlton Reserve. It contained a confession, if you will. The FBI says it was statements that indicated that he was responsible for Gabby's death. And to this day, it's perhaps the most it is at the center of everyone's fascination when it comes to answering the question, why Brian murdered Gabby. And so Linda Fontaine is asking here, #KJB, if there is a trial, would the journal be talked about? So Peter, what evidence is potentially on the table should this proceed to a jury trial, but one in circuit court centered around a civil lawsuit? What would be the chances that the journal would get introduced as evidence, or perhaps even screenshots of it or mention of it? What do you say?
There's a lot of potential things that can happen, obviously, right? Because there are hearsay issues, but then there are exceptions to hearsay when the declarant is deceased. I think any relevant and admissible evidence is going to come in, right? So if they can show that the journal, they can get their hands on the journal first off. And then secondly, if they can show that there is a connection in the journal that says Brian told his parents this, and there were plans to do this or that or the other, or to mislead, or to say something that would hurt Gabby's parents, or whatever it may be, if there is something connecting the outrageous conduct towards Gabby's parents, then I think it would become potentially admissible in the case. I think just the fact that he takes responsibility for Gabby's death, that doesn't necessarily prove what Gabby or what Brian's parents actually knew in making their decisions that caused the emotional distress to Gabby's parents.
How about this question from Greg and Chris +6? That's a great name on YouTube. Oh, they got a great profile picture there too. #KJB, how in the world are they going to be able to find eligible jurors if this case does indeed go to trial? This case was so widely known, most everyone knows about it and is going to be biased. This is a million or billion dollar question for you, Peter. Is it possible to find somebody on this actually takes us now to Johnny Depp, Amber Heard territory, right? Finding jurors that are as unbiased as can possibly be, given the wide availability of mainstream media and how we have information at our fingertips, and really the entire world knew about Gabby Petito's disappearance and the manhunt for Brian Laundrie. So how do you answer this question for Greg and Chris +6?
So my answer is there's been bigger, and we have found fair and impartial juries, just like Johnny Depp. There are other ways you can get jurors from out of town. But again, today's day and age, that's becoming less and less important because of the internet, and people from out of town can still know about the case. And that's exactly why this is so important for Gabby Petito's family. If they do get in front of a jury, they start out way ahead of Brian Laundrie's parents. So that's why the judge has to be the gatekeeper in this case, determine whether or not it should go to a jury. And if it does, just like Johnny Depp started out ahead and then ran away with it, I think Gabby Petito's parents will start way ahead, and those arguments of you could have made an anonymous call will go a lot further with a jury than they should with a judge.
Very interesting. Let's get to some other comments coming in, everybody. I'm reading as many as I can here. Oh, this is a great legal question, Peter, that, again, glad that you're here because Peter being an expert in Florida law. A season life with Allison DeLong. #KJB. Isn't the right to remain silent applied to people who were being investigated for a crime? At the time the Laundrie shut down, they were not under any position to be investigated. What do you think here for Allison's comment?
Yeah, the answer to that is no. It's not only when somebody knows a crime has been committed. It's not only when you're under investigation for a crime. It is whenever what you say could implicate you criminally. You have the right to not say that, period. It's not like nobody knows about it, but I actually stole JB's car. Nobody knows about it, so I guess I have to talk about it if JB asks me if I stole his car. It's like, no, you have the right to remain silent to protect yourself from anything you say implicating you in a crime. So if they did cover it up or help them escape or did something like that, and their statements would have indicated that, which would have implicated them criminally, they have the right to remain silent.
This question from Diane Seawald, #KJB. I can chime in on this. How can the Petito attorney prove that the Laundries knew Gabby was deceased? This goes back to the lawsuit being filed back in March, and that was the big bombshell that was dropped, the big bombshell allegation that was dropped by the Petito and Schmidt family, claiming that upon his return without Gabby from this cross-country road trip, upon his return to the Tampa Bay area, Brian Laundrie informed his parents that he had killed Gabby Petito. Now, how would the Petito and Schmidt family know that this conversation took place? Well, again, in my conversations with Pat Riley, the attorney, that they're sitting on evidence, and they said they wouldn't have put that in the lawsuit had they not had the evidence to back it up. They're not here to just throw allegations at the other side. They say, and this is their claim now, that they have something to back that information up. So Diane asking, how can the Petito attorney prove that the Laundries knew Gabby was deceased? It comes in the form of evidence, and it might not be a form of physical evidence. There could be testimony that comes to light, right, Peter, that illustrates that the Laundries did in fact know what happened to Gabby. If that's, do you agree with that?
Testimony is evidence. That's
Testimony
enough
is
to prove a case.
And let's not forget that the initial witness list was revealed, and I'll see if I can bring it up. I do have it here on WFLA.com. Give me a second, folks, and I'll bring it up. So the initial witness list, it's very procedural. It's by no means who exactly would appear should this go to a jury trial, but this is a list of people that, at least at this stage, the Petito and Schmidt family have expressed interest in hearing testimony from should it go to a jury trial in August of 2023. It reads as follows: Joseph Petito, Nichole Schmidt, Tara Petito, James Schmidt, Chris and Roberta Laundrie, and then representatives of the FBI, representatives of the Northport Police Department. So if the FBI and agents with the FBI or investigators with the FBI are called up to testify and are under oath, and they are asked about these sort of questions, could that be the evidence that the Petito and Schmidt family are referencing in, as far as knowing that Gabby Petito, that Brian Laundrie's parents were informed of Gabby's death on August 28th or near that date?
I think it's really interesting too how the connection with law enforcement is going to happen in this case, because a lot of people think they messed up. A lot of people think they did things that were wrong potentially. Are they going to be open and forthcoming throughout the process and help Gabby Petito and their team? Are they going to be tight-lipped and afraid that maybe the barrel will be pointed at them at some point? It's going to be interesting to see how all of this kind of comes together, but we'll see. We'll see what happens. That's what happens in litigation.
Linda Gale with this question here. We're going to go back to the other one that just came in, but Linda Gale, #KJB, did Gabby's family ever see the journal? I've asked this question before. I have not gotten an answer. I haven't gotten a yes or a no on this question. Has Gabby's family ever seen the notebook? Unknown, at least based on my reporting, that is unknown at this time. How about this one from LB? Well, we just had up one that I missed that I'd like to get back. Hold on, we're scrolling back up here because I did have a comment that I missed. Folks, this is when we have this many people watching.
A lot of comments.
It's a lot of comments. Peter knows from doing it on his YouTube channel. Let's stick with the one here. Apologies to the person that I missed. LB Abstract Art, #AJB. If the Laundries didn't know a crime had occurred, why bother hiring a lawyer in the first place? It's mentioned in the lawsuit that a retainer for Bertolino Services was sent. I believe the date was September 2nd. So do you make something of this, Peter, that before September 2nd is well before this case blew up the way that it did as far as the media goes. So them already having the attorney in place pretty much right after Brian had returned home to the Tampa Bay area, what does that mean to you?
To me, it can't be used against them. It just frankly legally can't be used against them. It can't, the inferences that it can be made are arguable. But to me, that doesn't really prove anything. They don't know what happened. He could have just told them that she disappeared. He doesn't know what happened. He could have also told them about the physical altercation they got in that we all saw that body cam footage of, and he could have hired the lawyer because of that at first. We really don't know. That's the whole point. Is a lot of it is privileged, a lot of it is confidential, and it's really hard to make these jumps and make these guesses and make these inferences because I hate doing that. I hate speculating on something that I just don't know. There's a lot of reasons to hire a lawyer potentially, and one of them could be because he said, I murdered her and hid her body. He could have said that. That could be a reason. I just don't know what the reason is, and I know that the judge is not going to let them infer guilt for the fact that he hired a lawyer.
For SoCal Renee Gal, hashtag HJB, you mentioned my question but didn't read it. If you file it again, I tried to scroll back up to find it. I'm sorry. If you resubmit it, I'll look for it here in the comment section. While we got you, Peter, checking in on your schedule. You're, of course, you're a busy guy. How much longer do you have with us on stream before we?
I've got about 5 more minutes.
Okay, 5 more minutes.
Till 3:30, yeah.
So last call for questions that are of the legal variety that perhaps Peter can answer for us while we've got him on stream. I'm going to give you a yes or no, Peter. Do you anticipate this going to trial in August of 2023?
No. I feel confident saying no in August of 2023 because I have so many outs there if I'm a betting man, right? It could get dismissed. They could lose eventually on summary judgment, which I kind of think almost is what Judge Carroll was kind of intimating, where he said, I'm not sure this whole Fifth Amendment argument is right for during a motion to dismiss. That doesn't mean later it can't come once we have more facts and more discovery, meaning on a motion for summary judgment, I could throw it out. But then also, I will always bet on a case getting continued and getting delayed. So that's why I'm going to say, no, I don't think it's going to trial August of 2023. If you say, will it go to trial ever? That one, I'm not sure of.
Percentage chances that it ever goes to, I have to ask, percentage chances it ever goes to jury trial?
I would say less than 10%.
Wow. Less than 10%. I want to make sure I heard you right. Less than 10%.
Less than 10%, meaning 90% chance the case either gets thrown out or it gets settled or something else happens to where this does not get to trial.
What about the wrongful death suit?
That's not, that could have a higher chance of going to trial, especially if it's unopposed, and they could go get some $500 billion verdict against the estate of Brian Laundrie that they collect $20,000 or whatever is in his estate. So that case they're going to win. It's just how big of a number do they want to get? How much time and resources do they want to put in it? They could have an unopposed trial, which I had a friend that did that in Tampa and got like $100 million verdict or something on it that you don't collect, but it's more likely that goes and they go get a victory in that case for sure.
Let's get to a couple of these questions while we've got now probably about 4 minutes with Peter Tragos here, everybody. Let's get to trying to read these as quickly as I can. Oh, yeah, no. Yari, hashtag AJB, hashtag lawyer, what did Pat mean by he would need only 1 or 2 for the case? That is the wrongful death suit, not to be confused with the civil lawsuit that, of course,
and again,
focusing in on.
That makes sense. You only need 1 to 2 days if it's unopposed, and you just get to put all your evidence up and ask for a huge number, and they give you a huge number. That makes total sense for 1 or 2 days for that trial.
Meryl Kronk, hashtag AJB. If the Petitos win, can there be a criminal case against them?
So there are 2 separate avenues, criminal and civil. And right now, there's no criminal investigation that I'm aware of, no criminal charges against the Laundries. Now, if the Petitos bring out some kind of evidence that can prove criminal liability, then law enforcement can look into it and potentially bring charges. But the Petitos can only prosecute civil cases. The government is the place where you have to be prosecuted for criminal cases. We can't choose as private citizens to charge people with crimes.
David Niles, hashtag HJB. What will it take for that notebook of Brian's to be made public?
So honestly, it could come out, it could be in discovery, it could be used at trial, and they could still keep it private. They could still do in-camera reviews. We still might not be able to see certain parts of it. It's just the judge has to make a decision of the privacy rights of the Laundrie family and Brian Laundrie potentially, and then the public's right to know what's going on in a case and what's happening in their community. So it'll be a balancing act.
Everyone's gonna have to forgive me. I cover a lot of news. It's not just Gabby Petito and Brian Laundrie. A lot of people, I think, associate me with that story because, of course, how much we covered it last year. But I'm just remembering that I submitted a FOIA request, and I never heard back. But you know what, though? FOIA requests, Peter, I'm sure you know, they can languish in purgatory in that middle space, that gray area of nowhere for not years, but sometimes decades. So I'm not holding my breath to get any information. I submitted for everything under the sun with this case, hoping that the FOIA request would turn up something that I could use to help people understand the truth of what happened, and I haven't heard back from the government.
Not unusual.
Not unusual in the slightest. 1 or 2 more before Peter's. I'm going to stay with everybody on stream for a little bit longer and talk about where this goes from here. And also, I have something to talk about as far as like a public service announcement. But let's just kind of go through some of these finals final questions and comments. Miranda, #KJB, how are they protected not to speak if them not speaking is the literal definition of accessory after the fact?
So not speaking doesn't on its own make you an accessory after the fact. You have to actually do things to help them after the fact, to hide things, whatever it may be. Not speaking, you have to, by not answering these questions, like, for an example, you can't just say that I'm going to invoke my Fifth Amendment right because I know somebody else committed a crime. You have to invoke the Fifth Amendment right when you're protecting yourself from criminal implication. That's how it has to be done. You have to actually have already been an accessory when you invoke your Fifth Amendment right.
How about,
or at least have things that could be incriminating that you would say. Right.
How about, oh, I just had it. It's scrolling. There it is. Gino, 007able. Okay, we'll go with that. #AJB. If they get a judgment for the wrongful death, does all the property become the property of the Petitos?
So anything that's a collectible asset potentially could. We don't know. I don't know what his situation is, his financial situation, whether he has more debt than he has money, whether he has more money than he has debt, if he owned any property that wasn't homesteaded, if he had any cash in his bank account. I don't know anything like that. I don't know how the probate process has gone with him, but potentially they could collect his assets, yeah.
We'll end with this comment with Peter on stream. Danny Power, #KJB. I think people need to realize that even though most of us believe the Laundries were involved in what their son did, the evidence could say the opposite. It's about evidence, not feelings. I feel like that last statement, it's about evidence, not feelings, kind of sums up what Peter has really been trying to hammer home, not just on this live stream, but on his legal analysis streams on the Lawyer You Know YouTube page. Peter, I'm going to let you react to this comment and also just kind of give you the last word here before we let you go. Your analysis in closing on this pretrial hearing in the Gabby Petito lawsuit.
Yeah, I agree with this, Danny, and it's about the law and the evidence, not just our feelings, because we all feel for the Petito family. And that's why when we talk about that wrongful death claim, 100% certainty they should win, and they should win a lot of money. So nobody is saying that they don't have any claims or that nothing bad happened to the Petitos or anything like that. We're just looking at the law and the facts in this case and seeing if a duty was actually breached by the Laundrie parents for remaining silent when they feel like what they said could have incriminated themselves potentially. And that's really what it comes down to in this case. And I'm interested to see if this does go before a jury, if they will just totally throw the law out and go with the facts, and emotion could potentially lead them to a big verdict for the parents of Gabby Petito against the parents of Brian Laundrie.
Peter Tragos joining us here, everybody. The Lawyer You Know, give him a follow, a subscribe on YouTube. And hey, congratulations to you, sir, surpassing 100,000 subscribers. He did great work on the Johnny Depp Amber Heard trial, folks. And he continues to do live streams on that. So, Peter, you're always invited on WFLA Now. Thanks a whole lot for joining.
Appreciate it, guys. See you later.
All right. Peter Tragos, everybody. Back here with you live on WFLA Now. Danny, thank you for your comment. Let's get to some of the others. My cat's name is Karen. That's an interesting name for a cat. I'm going to be honest. I would not name my cat Karen. I would find as a cat lover, I would tell you that I would find a different name for my cat. But your cat's name is Lauren. And I'm going to say #KJB is Brian's sister on the witness list. The answer to that question is no, not at this stage. Could that change? Absolutely. There is so much time between now and a potential trial occurring. But if you believe Peter, there's only a 10% chance that this ever does, in fact, reach the jury trial stage. That was a number lower than what I was expecting. And let me explain a little bit why that's lower than what I was expecting, and perhaps the number that I had in my mind. And I'm just going to be, this is stream of consciousness. This is just me being real with you. I'm not on anyone's side here. I'm not on a team. I'm not rooting for one side or the other. I am on the side of fact. I'm on the side of uncovering the truth. That is what we do as journalists. It's what we do as reporters. We want to know what really is happening. We want to know the facts. We want to know the truth. And if this avenue gets us closer to the truth, then I'm for that. If the civil lawsuit uncovers information that was previously unknown, information that is so pertinent to this investigation or the investigation that was conducted by the FBI, then I'm all for things going forward. I just want truth. I just want information. I just want to be able to inform you as to what the fact of the reality is with a given situation on all the stories that I cover. So we're always chasing fact. And so I am never going to betray you like that by saying that, oh, I support this side of an issue or that side of a particular argument or dispute. No, that's not my MO. That's not how I conduct my business. My business is giving you good, credible, concrete, fact, good information about the stories that we cover. And I'm only hopeful, more than only hopeful, I am hopeful that we haven't learned our last fact in the Gabby Petito story. I am hopeful that we find out more because I believe, in my opinion, that the public deserves to know more, that you deserve to know more. Karen Griswold, #AJB, isn't the FBI warrant for Brian still active? It's not active with somebody who is deceased. It was a warrant that was issued for unauthorized access devices. That was the charge of illegal use of a debit card. That was just really what that was a device used by the FBI to have something that if Brian Laundrie was walking in the woods and the FBI had found him without that FBI warrant, they can say, oh, hi, you're Brian Laundrie, hello, and they can let him continue walking. He is no different than any other ordinary American citizen with the law. But the fact that that federal warrant was issued for use of unauthorized access devices, again, fancy words for illegal use of a debit card, they were able to apprehend him on site. And so, in large part, if you ask the FBI what the purpose of that was, I think that they would tell you. The FBI is never going to tell you anything, but the FBI would tell you that that was really the most noteworthy purpose of that arrest warrant. But to answer your question, Karen, it's not necessarily active. The warrant is against a deceased individual. I'm good. Are you? #KJB. Thank you for bringing Peter on. It's so nice learning about the law. And good. Don't be like mainstream media. Facts only. This is part of the mission statement, folks. With WFLA Now is not just, of course, bringing you factual information and talking about the stories that we cover from a position where we can stay rooted in reality and have these conversations with you, but also to bring on experts and feature what you have to say. This is what we call, of course, interactive journalism, and thank you for the kind comment. Paulette Martinez, #KJB. If the Laundries claim the Fifth Amendment, does that prove that they knew would have posed this to Peter? It's a great question. But they're already, I believe, really starting to claim the Fifth Amendment. And so I don't think that they would legally bring up the Fifth Amendment if they had believed that it was going to cause legal trouble for them should the lawsuit proceed to trial. That's my very best take on doing a bit of legal analysis for you. Let's get to this question. I've already asked the family, LB Abstract Art, #KJB, you don't have to share this, but can you, of course I've asked this question. Can you ask Nicole if she's seen the Notebook? I've asked this question to, I'm just going to say this, I've asked this question to the family, Gabby Petito's family, in my conversations with them. And I'd be having similar, let me make this clear too, I'd be having similar conversations with the Laundries, but they don't talk to anybody. They don't talk to anybody. So, it's what my job is. My job is to ask questions. And of course, I asked this question. I was not able to get an answer whether or not the exact contents of the Notebook are known by Gabby Petito's family, and that's that they are under no, they don't have to answer that question. So that's up for them. I have asked it. I was unable to get an answer. DreamFaith14, #KJB. Will they be able to bring forth the fact that Brian used Gabby's credit card and him sending the text pretending to be Gabby? I think everything, see, that's the thing with a jury trial like this, right? Everything is potentially on the table. It's all there. It's all ready to be used and displayed in a court of law for the first time. So if it's going to be a piece of the puzzle for the plaintiffs to illustrate and prove their case, then it's on the table for them to bring up, as long as they are able to do so in a way that that is, backed up and is factual and is, rooted in what we know about the case. Amanda Holland, #AJB, thank you for covering this. Followed you since the first day of this. Thank you. That means a lot. And yes, we do cover more news than Petito and Laundrie. We do a lot of live streaming on WFLA Now with a lot of very talented people. I'm just going to say to Potato Face without animating it on screen, I think it's my turn tonight. Without bringing up, that's just between me and Potato Face on YouTube. David Niles, #AJB, wondering if anything in that notebook mentioned Brian taking responsibility for the newlywed couple's murders in Moab. If that had been in there, that would have been first of all, a monumental, colossal surprise. And two, would have been mentioned by the FBI. That's something that the FBI wouldn't conceal if it would have brought closure to another potential investigation. So I think that there's still a lot of folks that wonder that, and with theories and so on and so forth. But no, that would have been made known. I'm new here, says Kit Kat. Sub to the channel. Absolutely love your insight. Thank you for that. I will take a couple of final questions and comments here if I see any pop up on screen. That's Tyler's comment on screen. Let's clear that out. Okay. So we are going where this goes from here. We are going to continue, of course, to monitor the latest. The moment that document is released on whether or not Judge Carroll rules in favor or against the motion to dismiss, we'll have it for you here on WFLA.com, the WFLA app. But I'll probably, first thing you do, I'm tweeting it out. I'm putting it out on Facebook, my Instagram page, so on and so forth. I'm keeping everybody in the know as that level of news breaks on social media. So if folks are really wanting to know that information as soon as it comes out, yeah, you can follow me at WFLAJB on Facebook, on Twitter, on Instagram. And really, again, as a reminder, we're 2 weeks away, or within 2 weeks, I should say, rather, is when Judge Carroll is expected to release his decision on the motion to dismiss, and whether we're one step closer to this going to trial or whether we're 40 steps back. So we'll, of course, keep you posted with where this goes. And let me just pass along, as we're talking about Facebook and we're talking about Twitter and we're talking about Instagram, I have been made aware. This is kind of a public service announcement, if you will, that is beyond this case. It's just in general. I have been made aware, and I have been sent videos of my reporting surfacing on TikTok. I have to talk a little bit about TikTok with you today. So please indulge me for the next couple of minutes as I talk to you about TikTok and that platform, because I know a lot of you are on TikTok, and I want this to be very, very clear with my position on this and where I feel about this. So TikTok was enormous, obviously, during the Gabby Petito, her disappearance, and of course the manhunt for Brian Laundrie. There was just endless content on TikTok, and I was way too focused on the case at hand and the story at hand than to go looking at all of the content that was emerging on TikTok. I was alarmed, to say the least, alarmed at how much misinformation that there was on TikTok, and in the period that existed between the FBI's conclusion of their investigation and this lawsuit, and being at this stage, in between these chapters, if you will, behind the scenes, I did a little bit of homework on just how much crazy misinformation that there was out there on TikTok. Now, look, when it comes to TikTok, okay, that's TikTok. That's just the platform. Nothing that I do, nothing that I say is going to control just the crazy circus, the chaos that is the platform known as TikTok. But what I have been made aware of in recent days is some of my reporting surfacing specifically on TikTok. People screenshotting my stuff and then posting it on TikTok. And I'm not going to sit here in front of you and say that I have a problem with that. That's TikTok, and that's really just social media in general. It's not exclusive to TikTok. People screenshot stuff all the time. That's not what I have a problem with. What I do have a problem with is when people take things that I report, use my face, use my name, post it, and do, have it behind them on TikTok, say that I'm reporting something when I am not. And there have been multiple instances of people using my name and screenshotting my tweets and my reporting on WFLA.com and then going on camera on TikTok and saying, oh, this is what's being reported, when it is completely false. That's a problem. That is a problem. Screenshotting my reporting and then passing it along to people on TikTok, okay, that's good. I am all for one of the biggest reasons I do what I do with live streaming is to pass along good, credible information. And if there's good folks out there that are good, responsible people that are sharing out that information on TikTok, then great. That's fantastic. Please share good, credible, rooted in reality information on TikTok. But when you take my name and you take screenshots of my work and then you go on camera and you say something that is completely inaccurate with my name and face behind you, that's a problem. That's a problem. And so I haven't had the opportunity to really talk with our audience about this, and I'm doing so now because I'm making it very clear I do have a problem with it. If you are going to use my name and you are going to screenshot my stuff and you are going to, pass along my reporting, will you at least do me the favor and report it accurately and not transform it and morph it into a falsehood? That to me is extremely upsetting, because I want people to recognize us, WFLA, and recognize this, what we do here, as being a credible source of information. I do not want to transform that way on TikTok. For the TikTokers that do it responsibly, thank you. For the people that just are rushing to get it on that platform and then take words out of my mouth or take words from my reporting and twist it and morph it into something else, shame on you. Shame on you. So it's not ready just yet, but I have made a TikTok account. I'm at WFLAJB on TikTok, and I'm not making for good, credible, solid, rooted in reality information. So if you're on that platform, I don't have any videos yet. I'm working on adding yet. I feel like that circus performer where they're spinning the plates on the sticks, that, and then I'm now throwing another 40 plates on. I already do live streaming work on Facebook and on YouTube and WFLA.com and the WFLA app, and I keep my followers up to date on Instagram at WFLAJB on Instagram, and now I'm adding yet another platform. But I feel like it's my responsibility to do so because some people just continue to erroneously report using my name and likeness on that platform. So that's the last that I will say about it. Very, very much looking forward to eventually going on to TikTok and creating content about Gabby Petito, about Brian Laundrie, about the stories that we cover here in Florida. And I hope that if you're on that platform, that you give me a follow if you are looking for stuff that is rooted in reality. And that's what I have to say about that. All right, some final comments before like Amanda's saying here, why would anyone take information and misconstrue facts? What does that help? Tell them, JB. So they're not doing it intentionally. I don't think anybody really wants to intentionally spread misinformation. They're just doing it because they don't understand. They don't understand the context of the stories that we cover. And this is what makes, and this is, look, everyone in this day and age can put on their hat and call themselves a reporter because they report information. But like, look, in our industry, we practice journalism ethics, and we practice fundamentals of journalism that are rooted in this law of being fact driven. And some people on TikTok, they don't care about being perceived as a journalist or not. If they're getting likes and clicks and shares and views and all that stuff, then journalism, they don't care. That's just a word that starts with the letter J. So I don't think that they're doing it intentionally. I just think that it is something that they're doing because speed is a factor on social media. We know that. And some people are just rushing to get videos on TikTok as soon as possible. And then they do so, and they do it so fast, they don't really consider what they're saying. It's so scary these days that somebody can hit 3 buttons on a phone, record a 60-second clip, and it reaches 1 million people within minutes. Scary. And we need to do so responsibly. Otherwise, we are in a very, very dangerous age of potential misinformation. And we probably already are in a dangerous age of potential misinformation. But Amanda, thank you for your comment. 2X Army drills, hashtag KJB. Do you think that maybe the Laundries might say something privately to the Petitos? The judge puts this to a jury just to keep it from going to a full trial? Long shot. If you're asking me, it's a long shot. Like at this stage now, they deciding to come forward. I can't see that. I can't see a scenario where that happens, or a scenario where their attorney would advise them towards that particular action. Folks, we got to get going here in just a moment. Brenda Fortnot, hashtag KJB. If the case isn't dismissed, will the Laundries be required to attend? As I understand it, the Laundries will be there and will have to be there, as I understand it. But I will triple check on that. Bullhorn Betty asking hashtag KGB, how do you feel about the Fifth Amendment argument? It's not for me. It's a law, and it's not for me to interpret as a journalist. It's for the legal experts and really the judge to interpret how the Fifth Amendment fits into this puzzle, Betty. So hopefully that's not really an answer to your question, I know, but we'll take 1 or 2 more before we got to get going. Yeah, okay, so let's talk about Cassie for a second. Atharia, hashtag KJB, will Cassie be dragged into this lawsuit against the Laundries? She could be called as a witness. She was at Fort DeSoto at the camping trip. The vacation was mentioned in a pretrial hearing. So you know it's going to come up should this go to a jury trial. Cassie might get called as a potential witness. Also, I thought that this was interesting. Did anybody else catch this? Pat Riley, the attorney for the Petito and Schmidt family, said that they would have added a third person to the lawsuit. They would have added Steve Bertolino as a defendant of the lawsuit if he was a Florida resident, but they couldn't because this was filed in Florida and Bertolino isn't a Florida resident. I thought that to be very, very fascinating. And so, look, Cassie is a Florida resident and isn't in the lawsuit. I think that the Petitos and the Schmidts, I would just say that, look, if they wanted to include Cassie on this lawsuit, they could have included Cassie on this lawsuit. They absolutely chose not to. Some of the kind comments like Adam and I'm good, are you? Some of the kind comments, Scooter, a lot of folks that are commenting. Really appreciate some of the love. Thank you. Yes, if you would like to, I don't have any videos there yet. You're following somebody with 0 content, but if you'd like to follow me on TikTok, you can do so at WFLAJB. I'm going to try to post good, meaningful, factual, truth-based comments, videos, content on my WFLAJB TikTok in time. about this story and others that we cover. You can also follow me on my all my social media accounts are the same, at WFLAJB on Facebook, Twitter, Instagram, and yes, now TikTok. I'd like to take a special moment to thank the moderators. Let's give just a really quick, yes, I have the round of applause sound effect. I don't get to use that much in the news industry, but just thank you to our moderators on YouTube. You know who you are. Thank you for helping keep our comment section a clean and safe place for all of our commenters to be and to converse and to disagree and agree. Thank you for what you do here on the WFLA YouTube page. To everybody joining us, I will be posting updates, including maybe later today, if I learn new information, if I get more from the people that I talk to about this story. If I get any more information, I'm posting it on my WFLA JB Facebook, Twitter, Instagram, TikTok in the future, not yet. And again, my promise to you is to always stay rooted in reality with the stories that we cover, this one and all of them, rooted in reality. Thanks so much for joining us here, everybody. The very latest on this story. Yeah, you can click on the link in the description of this video. It'll take you to WFLA.com, the WFLA app. If you're joining us from a Nexstar sister station website or app, you can also click on the link in the description on that video. It'll take you over there as well. Big shout out to our Nexstar Nation partners who also were partaking in this stream as well. I'll post updates as they come in, and all the latest article content is there for you on WFLA.com and the WFLA app.